Welcome to the 8th and final lecture in Module 4. Today we will be talking about police interrogations and the issue of false confessions. At the end of this lecture, you should be able to differentiate a police interview from an interrogation, describe typical suspect interrogations, explain the legal rules governing police questioning, discuss the problem of false confessions and name the practices that lead to false confessions, identify 4 ways that detectives can prevent false confessions, name at least 5 recommendations offered by IACP to reduce wrongful convictions. When a detective questions a victim or a witness, it's called an interview. When a detective questions a suspect, it may be considered an interview or it could be considered an interrogation. As you can see from the slide in front of you, there are some not so subtle distinctions between interviews and interrogations. Interviews are intended to be information gathering sessions. They are generally inquisitive and conciliatory, not accusatory. The format of an interview may resemble a dialogue between interviewer, detective, and interviewee, or a friendly Q&A session. Interrogations, on the other hand, are different from interviews in that they are only conducted with suspects, not witnesses or victims, and they are aimed at learning the truth about the suspect's involvement and ultimately eliciting a confession. Unlike interviews, which are generally inquisitive in nature, interrogations in America are usually accusatory, though this is not necessarily the way it is in other parts of the world. The detective generally has some solid information about the suspect's involvement in the crime prior to commencing an interrogation. According to BJS, 82% of investigators receive special training on how to conduct interviews and interrogations. The most common interview method used in the United States is the Reid technique. Since 1974, more than 500,000 investigators and security personnel have been trained in the Reid technique, which is composed of 3 stages: factual analysis, behavior analysis interview, and interrogation. The first stage involves a factual analysis of the crime facts to determine whether a potential suspect could possibly be the person who committed the crime, based on factors such as suspect demographics and physical description, opportunity and access to commit the crime, knowledge needed to commit the crime, motivations, and propensity to commit the crime. During the second stage, a behavioral analysis interview is conducted to assess the suspect's truthfulness using a structured set of behavior-provoking questions that elicit specific behavioral responses that are supposed to differ based on a suspect's guilt or innocence. Finally, the interrogation is a 9-step process that is primarily confrontational and intended to be used on suspects whose guilt is reasonably certain. You can read about these 9 steps on the slide and in the book. As your book indicates, the best interrogators limit their talking and try to listen for the vast majority of the interview. Detectives should avoid using leading questions and providing hypotheses or educated guesses about how the suspect committed the crime. A typical interview or interrogation lasts approximately 1.6 hours and is conducted during normal waking hours. Most suspects are questioned 3 times on average per investigation. The first couple are certainly interviews, while the latter or last one is customarily an interrogation. There are 4 basic types of interrogation strategies that are combined within the 9 steps of the Reid interrogation technique and which are practiced by investigators using other interrogation methods. The first, isolation, rapport, and minimization, involves a detective isolating the suspect away from family and friends, developing a rapport with the suspect, and minimizing the moral seriousness of the crime. The second, confrontation, involves confronting the suspect with a statement of guilt and a case filed to appear there is evidence against him. Essentially, the detective accuses the suspect of a crime and suggests that the paperwork in the file establishes his guilt. The third technique, threatening the suspect, has a detective threaten the suspect with consequences if she doesn't tell the truth. The fourth technique, presentation of evidence, involves showing the suspect some of the actual evidence against her. Almost all suspect interrogations include 4 elements: isolating the suspect away from family and friends, placing the suspect in a small private room, identifying contradictions in the suspect's account, and trying to establish a rapport with the suspect to gain trust. Many interrogations also involve the detective confronting the suspect with evidence of guilt and appealing to the suspect's self-interests. The first major U.S. Supreme Court case pertaining to police interrogation was Escobedo versus Illinois in 1964. The case provided that a person's right to counsel begins as soon as the person is a primary suspect when questioning becomes accusatory, not upon appearing in court on a felony charge, as was the previous decision. It came 1 year after Gideon versus Wainwright, which established that indigent defendants accused of felonies in state courts have a right to counsel provided for them. A mere 2 years later, the U.S. Supreme Court supplanted the Escobedo decision with Miranda versus Arizona in 1966, which stipulated that officers must advise suspects of their rights to free legal representation and against self-incrimination. Miranda is often misunderstood. However, it's actually quite simple. The Miranda notification requirement kicks in when two conditions are simultaneously met: custody and interrogation, police questioning. When a person is in custody, in other words, not free to leave, and is being questioned about a crime, police need to provide the Miranda notification. If a person is being questioned but is not in custody, in other words, they are free to leave, no warning is required. Similarly, a person who is in custody but is not being questioned does not need to receive the Miranda warning. An officer might choose to provide the warning, but he's not required to at that point. A suspect must be unequivocal in his request for counsel, meaning he must say, "I want a lawyer." At first, police were afraid Miranda would destroy their ability to solve crimes and gain confessions. But studies have found that Miranda has had very little effect on law enforcement's ability to apprehend suspects, elicit admissions of guilt, solve crimes, or gain convictions. There are two reasons Miranda has had such a minimal effect. One, most suspects routinely waive their Miranda rights. Only 19% of suspects invoke their Miranda rights immediately upon being informed of them. Most suspects, 81% of them, waive their Miranda rights and talk with an officer. A small portion, about 13%, waive their rights initially and then invoke them at some time during police questioning. A full 2/3 never invoke their rights during police questioning. The second reason Miranda has not had much of an effect is because police comply with the letter of the law, but not always the spirit of the law. For example, after giving the warning, an officer might put a suspect or two in the back of a patrol vehicle or an interview room with cameras rolling to capture incriminating statements, or an officer may make statements about the crime in the suspect's presence that are very tempting for the suspect to respond to, or an officer may continue asking the suspect questions until the suspect says the exact words, "I want a lawyer." Of those who agree to answer police questions, 2/3 of suspects make self-incriminating statements. Only 1/3 make no admission or confession during questioning. So why do so many suspects make self-incriminating statements? It's probably because they think they can talk their way out of trouble, that they are somehow smarter than the investigator conducting the interview. Unfortunately, that is rarely the case. Today, most detectives are highly trained interviewers, masters in the law, and skilled in the art of psychological persuasion. This is due to the advanced education and training that the vast majority of detectives receive upon being promoted into the position. So let me get on my soapbox here for a minute. Do not waive your Miranda rights, ever. Let me repeat that. Do not waive your Miranda rights, ever. It is never in your best interest to talk to cops about something you were involved in without a lawyer. Remember, cops are highly trained professionals, especially investigators. You are not. My husband, who is a reserve officer for more than 20 years, and I, like many in law enforcement, have taught our girls to never talk to the cops if they're being asked about something they did. They have been taught to tell the officer that they need to consult with their parent or a lawyer before saying anything. If an officer says to you, "If you have nothing to hide, then there's no reason not to talk to me," or something along those lines, don't fall for it. Put it right back on him and point out that if he was in your shoes, the first thing he would do would be to talk to a lawyer. In fact, most cops involved in on-duty officer-involved shootings must consult with a lawyer before giving their version of the events. So police protect themselves. It's in their best interest to get you to talk, and to get you to talk without a lawyer, because you're more likely to make incriminating statements without a lawyer. So you, my friends, are going to be just as smart as the cops are, and you're going to consult with a lawyer first. Remember, they cannot infer guilt from your refusal to talk. Just protect yourself, okay? I'm going to get off my soapbox now. So Miranda, along with other professional developments, has transformed interrogations without undermining detectives' crime-solving capacity. Contrary to original feelings when the decision became law, police have come to embrace Miranda as a legitimating symbol of their professionalism. Some scholars argue that Miranda motivated police to develop more sophisticated interrogation techniques. It's important to know that there's a significant power imbalance in the interrogation room that puts suspects at a major disadvantage and can cause some suspects to falsely confess. This imbalance is caused by multiple factors. First, detectives are highly trained interviewers and experts in the law. Second, suspects are generally not knowledgeable about the law or interview rules and are unaware that police can legally use deception during questioning. Career criminals and streetwise offenders, especially those who are part of a criminal network, may be exceptions to this assumption. Third, detectives have the ability to frame the suspect's actions to other criminal justice practitioners. In other words, they can put in a good word with the prosecutor, for example. Fourth, suspects' movements are controlled by detectives. The suspect must ask a detective to use the bathroom, to eat, to drink, to take a break. Fifth, suspects have a lot more at stake than the detective, namely their freedom. And finally, interrogations take place in the police station, a place that's very comfortable for detectives, but not at all comfortable for suspects. Also, interrogators are not neutral or impartial. Their goal is to build a case against the suspect by incriminating him and building a narrative about the crime that will ensure a successful prosecution. For these reasons, interrogation has been likened to a confidence game where the detective is the highly trained con man and the suspect is the gullible mark. False confessions are not a new problem. The issue has existed for a lot of years. The cause of the problem, however, has changed as interrogation techniques have evolved. Unlike 80 years ago, when false confessions typically resulted from physical coercion, the third degree, today they result from the highly persuasive psychological interrogation practices used by detectives. Although a small minority of suspects make false confessions, it's an important issue and one that has drawn increased scrutiny in recent years because false confessions are one of the leading causes of false convictions. The others include eyewitness misidentification and unvalidated or improper forensics. Of the more than 300 innocent defendants exonerated by DNA evidence in the past 25 years, more than a quarter of them made incriminating statements, confessed, or pled guilty. So despite the fact that it's hard for most of us to understand why a sane person would admit to committing a crime they did not commit, it happens, and it happens more than we'd like to admit. There are three main reasons why suspects offer false confessions. Some individuals provide a voluntary false confession to gain fame or notoriety, to protect another person, or because they, due to a mental or psychological condition, are unable to discern reality from fantasy. Others provide a coerced, compliant false confession in response to extreme methods of interrogation because they simply want the interrogation to stop and they believe that by confessing to the crime, by doing what the investigator wants, that will result in a more positive outcome than continuing to tell the truth, to the detective's dismay and the suspect's discomfort. Finally, some suspects provide a coerced, internalized false confession because they have been convinced incorrectly of their guilt. This generally comes from presenting false evidence and detectives telling suspects that they have camera footage of them someplace that they weren't, or they have some other type of evidence against them, or somebody said it was them. More than 250 interrogation-induced false confessions have been documented in the past 50 years. Detectives are more skeptical of and more likely to recognize as untruthful voluntary false confessions than police-induced false confessions. Thus, false confessions that lead to false convictions are typically coerced, in other words, police-induced. Also, because the pressure to solve a case is greatest for serious crimes, false confessions happen most frequently in very serious cases. Of the 873 exonerations that occurred in the U.S. between 1989 and 2012, 135 or 15% involved false confessions. Most of these, 80%, were coerced, and 75% happened in homicide cases. The problem is that once a person confesses to a crime, they are treated more harshly at every stage of the criminal justice process. They are more likely to be incarcerated prior to trial, more likely to be charged, less likely to be offered a plea bargain, more likely to be convicted. Criminal justice practitioners and jurors are both biased against the suspect because they believe the confession is true. In fact, there's a 73 to 81% chance of being convicted, even if there is no other corroborating evidence once somebody confesses to a crime. There are 3 police interrogation practices in particular that are likely to lead to false confessions. The first one that we'll talk about is minimization and promises of leniency. Detectives use minimization techniques to provide the suspect with moral justification for having committed the crime using a variety of themes. For example, the detective might empathize with the suspect, normalize the crime, then offer excuses or justifications why the suspect might have committed the crime. For instance, he was provoked, he succumbed to peer pressure, he was under the influence of drugs, or it was accidental. Another example might be empathizing with the suspect who killed their domestic partner or spouse, and the detective suggesting that she and the jury would understand if the suspect committed the crime in self-defense or to stop abuse. Such tactics encourage the suspect to make a confession and implicitly insinuate that a confession will be rewarded with leniency in the court and other privileges, like going home, having a meal, leaving the interrogation room. Another sketchy interrogation practice that leads to false confessions is when the detective presents false evidence to a suspect in an interrogation to gain a confession. It is highly controversial and allowed by U.S. law. Some law enforcement agencies, however, discourage the practice because it has been implicated in the majority of documented police-induced false confessions. Here, detectives pretend to have incriminating evidence against the suspect. The detective may make false assertions, say they have evidence they don't actually have, but they may not actually fabricate evidence. In other words, they may not create an actual report or piece of evidence with the suspect's name on it to back up their fictional story. They may, however, use props, as long as the props cannot be mistaken for actual evidence against the suspect. For example, a bag containing clothing fibers from another case is acceptable. Deceptive practices cause suspects to question their memory and make incriminating statements based on their false belief that they were somehow involved. Finally, lengthy interrogations can lead a person to confess to something she didn't do just to get out of the situation. The standard interrogation is short. It lasts between 30 minutes and 2 hours. Interrogations that lead to false confessions, however, are typically much longer, 16.3 hours on average. In a study of proven false confessions, researchers found that 73% of false confession interrogations lasted 6 or more hours. Prolonged isolation from significant others and other deprivations can exaggerate a suspect's distress and provide the motivation to do whatever it takes to get out of the situation. Similarly, sleep deprivation, which is an aspect of extremely long interviews, impairs human functioning, including decision-making ability. Police must be particularly careful when conducting interrogations of individuals from sensitive populations who are more suggestible or who may not understand the long-term consequences of their statements. In particular, juveniles and individuals with mental impairment are overrepresented in the proven false confessions population. Children and adolescents are less mature, both psychosocially and cognitively, than adults, and are prone to impulsive decision-making and risk-taking. They are more susceptible to negative influences, and they are less able to predict long-term consequences. These facts put them at much greater risk of providing a false confession. Likewise, individuals with diminished mental capacity are overrepresented in false confessions for many of the same reasons, especially a heightened susceptibility to influence, a desire to please, and an inability to understand the interrogation process and consequences. Detectives should avoid presenting false evidence to suspects who have no recollection of the event due to alcohol or drug intoxication, injury, or other issue. Make sure to read the article about how a researcher got a bunch of university students to confess to a crime they never committed. We now know that false confessions are not rare events. So what can we do to reduce false confessions? Scholars offer 4 suggestions, some of which are starting to become standard practice in some agencies across the country. Electronically record interrogations is one. Reform interrogation practices that disproportionately lead to false confessions is 2. Require all confessions to have corroborating evidence is 3. And 4th is to improve police training. So electronic recording creates an accurate, objective, comprehensive, and reviewable record of an interrogation. It also lessens the likelihood that investigators will use questionable tactics during the interrogation and protects the suspect's due process rights. Like body-worn cameras on patrol officers, a recording of the interrogation is a valuable investigative tool and compelling court evidence. A recording preserves the suspect's initial statement, which can be played back for the suspect or others later. It also allows a detective to review the interrogation as the case develops and new evidence is uncovered. Additionally, without the burden of note-taking, the investigator can focus more intently on the interview and the suspect's statements and nonverbal behaviors. Although many detectives and law enforcement officers were vehemently opposed to recording interrogations a few years ago, many who have experimented with the practice now endorse it and find the many advantages outweigh the few concerns. In fact, 25 states now require the recording of some interrogations. Unfortunately, California is not one of them. Scholars also want to see some interrogation practices eliminated, scaled back, or changed. Specifically, they want to regulate or ban the use of minimization techniques that include, either explicitly or implicitly, promises of leniency, because these lead innocents to confess by suggesting that complying with the detective's request will lessen the punishment or lead to other benefits, especially when the minimization techniques are coupled with threats that pleas of innocence will not be entertained and prosecution is inevitable. Those are what we would consider maximization techniques. They also want to forbid threats of physical harm or certain consequences for the same reasons. They want to prohibit or further regulate the use of deceptive, false, and misleading interrogation techniques because police lying about evidence is almost always necessary for eliciting false confessions. In fact, except in rare circumstances, false confessions do not occur without police deception. They want to restrict the length of interrogations because long interrogations increase the risk of false confessions by fatiguing suspects and impairing their ability and motivation to resist police pressures. And they want to disallow depriving suspects of physical essentials such as food, water, sleep, medicine, the bathroom, and support of human contact because doing so drains suspects' resolve and increases the likelihood of an involuntary and false confession that is later recanted. They also want to provide additional safeguards for vulnerable population that are more easily led into giving involuntary and unreliable statements that are disproportionately documented in false confession cases. And finally, they want to transform interrogations from the current antagonistic or confrontational approach to an investigative approach, such as the peace model, which is used in England. Another strategy to reduce false confessions is to require all confessions to have corroborating evidence. Detectives should make a practice of comparing the fit of the suspect's confession to the crime facts to ensure that the suspect's statement is corroborated by independent evidence. A false confessor's narrative, their accounting of events, will have guesses and errors and will be either inconsistent with or contradicted by available evidence. 3 indicators of reliability that have been offered by Leo and Offshee are: does the suspect's statement, 1, lead to the discovery of new evidence, specifically evidence that was not known to the police? Does it, 2, include identification of highly unusual elements of the crime that have not been made public, for example, killing someone with a lacrosse stick or a kid's ceramic art project? And 3, does it include an accurate description of the mundane details of the crime which are not easily guessed and have not been reported publicly? For instance, how the victim was clothed or positioned, how the room was decorated, what was taken, the name on the pizza box, on the counter, things like that. And then finally, in order to reduce false confessions, we need to improve police training. It turns out that investigators are no better than the rest of us at discerning a person's guilt or innocence based on their perception of demeanor, body language, and other nonverbal behavior. Officers are, however, much more confident in their truth-detecting abilities than the average layperson. Detectives should be trained on the variety and causes of police-induced false confessions so that they can be aware of and identify potential unreliable confessions and distinguish them from reliable and truthful confessions. And in fact, it's really heartening to know that IACP, the International Association of Chiefs of Police, is also concerned about this issue and has been working with the Innocence Project to reduce the incidence of false convictions. They want to be part of the solution, and that's really important. That's because they recognize that the damage that these cases cause for the criminal justice system, the public's trust in police, and public safety, since the true perpetrator is still at large, is enormous. Many of their recommendations are listed in the book, and you can watch the videos online that were co-produced by the Innocence Project, the Ohio Innocence Project, and IACP. That's one way that IACP is helping to improve officer training, by making those videos available to help officers recognize the potential of false convictions during the investigation process. So that's it, folks. As always, read your book, watch the assigned videos, check your knowledge, and let me know if you have any questions. Have a great day.